On a fourth issue of referrals, with respect to the Law Enforcement Integrity Division, all the heads of the law enforcement agencies that I've nominated for you have a mandatory obligation to refer corruption issues relating to their agencies where they have a reasonable suspicion that that is necessary. With respect to the Public Sector Integrity Division, the heads of the entities that would be covered by the Public Sector Integrity Division, that list that I've nominated for you, would likewise have a mandatory obligation to report suspected corruption issues relating to public sector staff. The standard that they would exact is if they have a reasonable suspicion that a listed offence has been committed in circumstances where there could be an abuse of public office. The head of intelligence agencies would notify IGIS. Intelligence agencies would be a part of the Public Sector Division of the new Integrity Commission. So the head of the intelligence agencies would notify the Inspector General of Intelligence of Security if they had a reasonable suspicion of one of those 143 corruption offences being breached. And the IGIS would consider whether that matter is appropriate for referral onto the Commonwealth Integrity Commission or whether it stays with investigation with the IGIS. And of course, the new Commonwealth Integrity Commission could receive referrals from any of the existing 11 integrity agencies. One important point to make, and why the legislation has been very complicated, is that we have always had at a federal level in Australia a multi-agency approach to integrity and anti-corruption. So my office has large Venn diagrams and spreadsheets about all of the existing agencies, their jurisdiction, how their referrals work. And this new body is designed to subsume the ACLI, which will become the Law Enforcement Division, create an entirely new Public Sector Division, have that new agency with a commissioner and 2 deputy commissioners sit as an umbrella and centralised agency on top of all of the existing 11 agencies, but also have to integrate with all of those so that there's not duplication or overlap and that there's a seamlessness to the referral processes that would exist. With respect to parliamentarians, there'll also be an ability to self-refer. That won't require reasonable suspicion, so if some issue arises with respect to a parliamentarian and they want that issue cleared up, they can self-refer to the Commonwealth Integrity Commission. And of course, all of the standard referral processes from any of the existing multi-agencies can also refer a parliamentarian. Finally, the listed offences. There are around 143 offences which the Integrity Commission could investigate to. They're listed at section 18 of the bill, and this bill also creates new offences of repeated public sector corruption, concealing public sector corruption, public disclosure of false or misleading allegations made or information given to Commonwealth investigative body, diverting resources of Commonwealth investigative bodies by making an allegation or giving information that is false or misleading, and notifying public sector corruption issues with no basis and with an intention to cause detriment. When the Law Enforcement Division or the Public Sector Division investigated pursuant to the standard of corrupt conduct or any of those 143 offences, the existing capacity of the Law Enforcement Integrity Commission would exist and be subsumed into the new agency, so they could hold both public or at their discretion, private or at their discretion public hearings. They can deliver reports on matters that they investigate into. The public sector side of the Integrity Commission is not designed to make public reports. It is designed to create briefs of evidence on any of those 143 offences in the public sector, which would constitute corrupt conduct, which would go to the DPP for public trial and conviction or acquittal, depending on how that trial transpired. Finally, the to-be-created Commonwealth Integrity Commission would report to, so be a part of the Attorney General's portfolio. It would be oversighted itself by an independent Inspector General, which would be a newly created position under the Act, and it would be oversighted by a standing parliamentary joint committee, and all of its coercive and investigative powers, so that is its ability to intercept phone calls and so forth, would be oversighted, as is usual with these things, by the Commonwealth Ombudsman. So I'm sorry if that's taken a little bit long, but that provides you with the 5 sort of central issues, I think, that arise with respect to the Integrity Commission. We will now embark on what I imagine would be a 6-month or so period of consultation. That'll be obviously amongst the public sector, civil society, stakeholders, all of the states and territories. I'd hope to hold roundtables. It's a complicated piece of legislation. It may well be that during that consultation process, some of the interfaces and interactions with the existing agencies are subject to scrutiny, and I'm not saying that this bill is beyond any improvement, but I think that gives you a description of how it will operate.